about that? Someone comes in who's doesn't have much money, but they certainly know that there must be some costs involved. What are the direct out-of-pocket costs, or are there any for someone who is thinking that I might have a case, but I'm not sure? How far do I want to go with this, and what can I possibly afford? How do you determine that?
In the med-mal area?
Yes.
It could run in the thousands. It could run in the thousands.
Many thousands.
Many thousands.
And what generally would happen is a lawyer who's done this type of work for a period of time has a good feeling for what type of case might or might not result in a verdict that's favorable to them. So if they really feel strongly about a case, they'll probably front the money for the costs and recover it back at the time of verdict or settlement.
Is that standard procedure, or are you just a nice guy?
It depends. If the case isn't as clear, the lawyer might say, I'm willing to front the money, but I'm going to want you to pay me back as it goes along if you can't afford to put it up front. Some cases, they're so unsure of, they're going to say, if you want me to take it further, you put up some money for the initial review. So it depends on the facts of the case, the extent of the injuries, and whether or not the lawyer thinks there's a likelihood of success.
Have you found many occasions where there should be a likelihood of success, but it really has not been worthwhile and you've spent an inordinate amount of time on it?
Yeah, myself personally, I had a case that I referred out to an attorney who specialized in the area. We met with the client a few times, and it looked like from the outset that there was negligence. We sent it out to a specialist, same type of physician that performed the procedure. It was a plastic surgery procedure. And we found out from the expert's report that the complications and the result from that procedure is something that is very common with this particular type of surgery. So to the individual, it may have seemed as though there was great damage to that person, but when in fact we get a report back from an expert that says, no, I don't really think that the doctor committed negligence, then you don't really have a case.
And here's another example. I had a case where a client went to a hospital suffering with abdominal pain. He was sent home. He went back again the next day, sent home again, and went a third time. And finally someone admitted him, and he had pancreatitis. And as a result of that, severe injuries, hospitalized for over a year, hundreds and hundreds of thousands of dollars in medical bills, approaching $1 million, and obviously could not work and was never able to return to work. Damages were extensive. The negligence to me was pretty clear as well. They just kept sending him home without performing certain tests that they should have done. And the expert that we hired said they should have performed these tests. We still didn't have a case. The problem there was, even if they had performed those tests and admitted him at that time, it wouldn't have made a difference as to what the result was. His pancreatitis would have developed and gone along exactly as it did, and therefore there was no causation between the negligence and the damages he suffered, and therefore no case.
Well, that certainly gives us another perspective about not all cases, as you say, are slam dunk, or none of them are, although they may seem to be. When we were talking about informed consent, we may later on talk about product liability, but what happens if a doctor is prescribing a medication that is experimental? If he didn't tell, or is he obliged to tell a patient that it's an experimental drug, and if it causes more harm than good or a worse outcome, is that negligence? Is that sue-worthy? Is there a case there?
I'm not sure that experimental drugs...
You'd
have to take part in a procedure with experimental drugs.
Generally, that's
you know
absolutely
you're
correct.
in that you know that you're in
clinical trials.
Yeah, most doctors wouldn't prescribe a drug that's in study, because I'm not even sure they're allowed to, but if they did, I'm 100% sure that they would have to inform you of that and give you a good introduction, because it's not well known as to whatever risks there might be in taking that. There's also, which I've seen a little bit of, prescribing drugs off-label. It's not designed for a particular malady, but they've found that maybe it helps with something. So doctors will often do that. Again, I think the same thing applies. If there are risks to taking the medication, the doctor has to inform you of that. And of course, the company that makes the prescription drug, when the package it, we usually send it
Package insert.
with all the risks associated with it.
That's good to know,
They
too.
mention the risks on the television commercials, too.
All the time.
sure
Right.
Yes.
we've heard that.
Ask your
Right.
doctor,
Yeah,
or maybe
yeah.
not. Certificate of merit, another one of the terms that we hear associated with personal injury. Define it. How does that apply to medical malpractice?
When you say certificate of merit,
Someone says, I think I have a case here, you're not sure. Is there a procedure that you have to go to see whether or not there actually is a bona fide? You described some of the steps that you go through, which can be quite lengthy and involved. Right. Is that what it takes for you to determine whether or not there is a case?
Massachusetts.
That's Massachusetts?
I think.
Well, you have to get through a medical tribunal,
Right.
and I think you have, it's not my area of specialty, but I think you have 1 year,
Yeah, there's a
a
process.
certain amount of time.
Different states, I understand, have
You have
different
to get past the
standards.
medical tribunal before you can even
File
file a medical malpractice case.
That just determines whether or not
Yes.
it's a valid, a
Yes.
bona fide case,
Right.
or
And-
Don't have that in
frivolous.
Rhode
In Rhode Island, my understanding is if you have a good faith reason to believe there was malpractice, you can go ahead and file the suit without having to clear it through a tribunal or the medical board or any of that type of thing.
Okay. I know in the earlier stages when we were starting to talk about medical malpractice, I mentioned that we all know it's a hot and contentious issue about tort reform. You made a comment, David, as I recall, that it's not really that much of an issue. So I think that
Yeah.
bears a little explanation.
It's a small fraction of the cost of medical care in the United States, the cost of tort negligent cases. The doctors usually make a big deal out of it. The insurance companies certainly make a big deal out of it. And I would be willing to assert that even if there was changes in the law, that wouldn't make the doctors' premiums go down.
It's not causing health care in general to go up?
I wouldn't think so.
No. If it
I
is,
don't think
it's
so.
minuscule.
So why do you imagine that it's such a hot and contentious issue if what you're saying has...
Because the
Yeah.
insurance companies don't want to have to pay medical malpractice claims.
At all.
They don't mind accepting the premiums, I'm sure, but they don't, if they can avoid paying out a claim, so much the better for their profit.
There are some states that put a limit on the amount of damages you can recover.
Well, that might be considered tort reform.
It is tort reform.
It is tort reform.
And
But what I think they're trying to do is they're trying to, federalize isn't a good word, but they're trying to
Yeah.
make it
A
nationwide.
national law,
standard.
yeah.
Yeah.
And traditionally, tort law has been state to state. It has not been governed by a federal rule. But if insurance companies can't win on a state-by-state basis, it may be easier for them to go nationally and see if they can assert and get some changes that way.
Another thing to stay tuned to. We've covered much of, or some elements of medical malpractice in the short time that we have left. Is there something specific that's on your mind that needs to be covered in reference to what we were talking about today?
In medical malpractice, there's a couple of things just to wrap that up a little bit. If you feel that you went through a procedure that was done incorrectly or you were somehow injured by a doctor, I would encourage people to go see an attorney that works in that area of the law. You may not have a claim, but unless you investigate it and do so in a timely fashion, 3 years later when you think you have a claim,
You'll
you're too
have it.
late.
That's a very good bottom line issue.
Right.
You've had several buyer beware issues for us to be thinking about going forward. I think the next topic that we'll be covering will be product liability, and specific questions we will take probably the following week.
Sure.
Good. Anything else that we need to wrap up here with medical mal?
I think medical malpractice we've covered pretty well.
Good enough. Again, Jackie Grasso, David Bazar, thank you so much for your help. We continue to invite your questions. Please email dbazar@abcglawfirm.com, and we appreciate your taking us through the morass of the legal system. Please stay tuned. The continued discussion of legal matters will be on product liability next session.